on the record in the matter of Heather Martin versus Kyle Zimmerman. So, Ms. Underwood, this personal protection order expires on April 26th of 2025. I do have a proof of service on the file that he acknowledged service on May 1 of 23. So he did receive notice of the PPO. The allegation is he violated by being present at the victim's home on November 27 of 24 at 0100 hours. So he has asked for court-appointed counsel. So I am going to put you and Mr. Zimmerman into a breakout room to discuss it. There you go. Join the breakout room, Mr. Zimmerman. All right, so we are back on the record, Ms. Underwood, with Mr. Zimmerman. Ms. Underwood, how would you like to proceed today?
Your Honor, I would ask the court to enter a not guilty plea on Mr. Zimmerman's behalf in this matter. I believe he may be looking at new charges, Your Honor. And I just want a chance to look everything over and also address new charges if they are forthcoming.
Okay, so I do know he has a bench warrant for failure to appear on a shoplifting charge and a bench warrant for violation of a court order. I don't know what that is. So you think he has new charges stemming from this as well?
I think so.
All right, so Mr. Zimmerman, I'm going to enter a plea of not guilty on your behalf. I'm going to set bond in the amount of $5,000 cash surety. Mr. Zimmerman, that way you're getting credit. I'm going to set this over to December 11th at 8:30 in the morning.
Your Honor, I'm sorry.
I'm gone next week, Miss Underwood.
I would wonder if the court would consider lowering that bond. It is the holiday weekend, and I'm sure.
So, Miss Underwood, what I would say is he would have to post $500 to get out. He actually has 2 PPOs. They just didn't meet him in the other one, and I don't know how that happened, but yeah. So I'm going to leave his bond at $5,000 cash surety. He can post a $500 bond through a bonding agency. I don't know what's going on with his new charges. I don't know the nature of the events that occurred that brought him there. So
I think it might be a resisting and obstructing, Your Honor.
All right. So I can change it to a $500 cash surety. But Mr. Zimmerman, I will tell you that if you go there, you end up risking getting a stalking charge and a felony. Do you understand that?
Yes, ma'am.
I don't care what reason you went there, or even if she invited you. If this PPO is in effect, it's my order, and I really don't like it when people violate my orders, especially PPOs. So just know that they can charge you with stalking and aggravated stalking or some other felony, and you could end up sitting in jail for a long time. Do you got it?
Can I say one thing, please?
No,
I
just say you understand what I said.
I just want to explain one thing, please.
No. You don't get to explain what happened, because anything, just stop. Don't say anything, because anything you say can be used against you. And if you admit to something or say something wrong, you could end up getting new charges. I'm going to set your bond at $500 cash surety. You can post that bond if you want, but I'm going to enter a plea of not guilty, and I'm going to set this over to December 11 at 8:30 in the morning.
And my children know that. She's having mental issues with my children.
No. Miss Underwood, did you talk to her about this?
I don't want him to make any statement.
Mr. Zimmerman, so, all right, we'll see you back December 11. As I said, your bond's $500. You just got to post, I think, $50. So, all right, we're all set, Mr. Zimmerman. Thank you. What's your name?
I'm here representing Brian Musgrove.
You're Brian Musgrove?
I'm here representing.
I have no idea what that means. So why don't you come up to the podium?
I tried to,
Nope, yeah, stand in front of the thing. So what is your name?
Brian Joseph Musgrove.
Okay, are you an attorney? What's your P number?
I'm not an attorney.
So then you can't represent Brian Musgrove. So
I'm
you
I'm
are a defendant, correct?
an executor on that estate.
Okay, so none of that is valid or legal. So you have an attorney?
He's not doing nothing for me.
Okay, that was my question. Do you have an attorney? Yes or no?
I have, yeah, he was supposed to be representing me, but
So you have Michael Dagger Margosian.
uh,
Okay, so he's your attorney. Okay, so go have a seat. When Mr. Dagger Margosian gets here, I'll call your case, okay? So, Mr. Musgrove, you want to come up to the podium, please? This is in the matter of the people of the state of Michigan versus Brian Joseph Musgrove, file number 23-21461FH. I have Isaac Sneed appearing on behalf of the people, and I have Michael Dagger Margosian appearing on behalf of Mr. Musgrove. Mr. Dagger Margosian might, oh, there he is. So, Mr. Dagger Margosian, this is a date and time set for pre-trial in this matter. Mr. Musgrove said that he was appearing on his own behalf. I did verify he is not an attorney, and you are still the attorney of record. So, Mr. Dagger Margosian, how do you wish to proceed?
Well, Your Honor, I am aware that Mr. Musgrove wants to present information to the court. I'm happy to be standby counsel if he wants to represent himself. Obviously, this court would have to go through the colloquy of that, but obviously it's Mr. Musgrove's legal right to at least ask the court to do that. So I'm here to observe at this point.
All right. So, Mr. Musgrove, when you were at the bench or up at the podium before, you said that you were appearing on behalf of yourself. So, Mr. Musgrove, are you asking to no longer have counsel represent you?
well, what I'm understanding is that the courts is a private
So,
for-profit.
Mr. Musgrove,
corporation.
I know where you're going with this, and none of that is valid. None of that is law.
I'm not the all caps name. Of course.
None of that is valid. None of that is law. You are
standing.
standing in my courtroom. I have jurisdiction over you. So,
I tried to file paperwork with the clerk's office ahead of time so that you would have time to review it, and they denied me.
I know what you're talking about. None of that is valid under the law of the state of Michigan or the Constitution of the United States of America.
What do you mean? It is.
No.
The Supreme Court says it is.
What does it say it is?
The Supreme Court says that if we were at the age of 18, we were supposed to claim our minor status.
Nope, not valid.
Okay.
So here's what I would say to you. Mr. Dagger Margosian is, like most of our public defenders, exceptional attorneys and very well versed in the law and very experienced. He gives legal advice. You may not like the legal advice, but it's usually good advice. I've never had anyone from the public defender's office not wholeheartedly try to represent their clients. So what you are talking about is not valid, and it is not going to get you out of this case. You're not going to be able to say all those things because it's not valid.
Everyone involved in this court case has a financial interest in the case.
I don't have a financial interest in your case. I get paid by the state of Michigan, whether you plead, whether it gets dismissed. I don't make any money off you. We have budgets. The court system is not a profit generating revenue. We are here to represent people so that people who are charged with crimes are protected. People who are victims of crimes are protected. And that's why we have all
But in order
these.
for there to be a crime, there has to be a victim. There is no.
Well, there is a victim in this case
The victim
because
would be the company. and the
you are
company-
charged.
I can't face. the
Actually,
company.
just hold on. So your crime that you are charged with, which you are innocent as of this time, let me grab the right file, is failure. Oh, this is let me see. This is an embezzlement charge. So you are charged in count one with embezzlement 50,000 or more, but less than 100,000. that being an agent, servant, or employee of Hardwoods of Michigan Industries did convert to your own use without the consent of your employer or principal, industrial tools and equipment in the amount of $68,938.40 or money or equipment. And that's a 15-year felony. So if you were found guilty by a jury, you can go to prison for up to 15 years. You're charged in count 2 with using a computer to commit a crime. To facilitate the charge in count 1, that carries a maximum penalty of up to 10 years in prison. And the way the statute's set up, I can actually stack those possibly. So you potentially could be looking at up to 25 years in prison. So the victim that's alleged in this would be that business.
Right, and I can't face that accuser because that business can't get on the stand for me to ask questions, and a third party.
But their
can't stand
representative
it.
can. Yes, they can.
They
Yes, they
can?
can. Yes, they
Okay.
can. So I have 189,000 of student loan debt that was forgiven to be a lawyer. You do not. And Mr. Dagger Margosian, Mr. Isaac Sneed, all of the attorneys here went to law school to know the law, and their job is to advise you of the law. So
Yeah,
yes,
but
they
they're
can. Yes,
They're
you
going
can be
by
charged.
everything, all the
can't-
laws and statutes that you guys go by
Are
for
legal.
corporations. They're for
Still a crime. Still a crime.
But I'm not
Still a
a fictitious
crime.
corporation, I'm a living person.
Yep, and that's why you're
Okay.
standing in front of me. If you were dead, the case would be dismissed.
Yeah, the all caps name is that.
That means nothing. That's not valid. It's
Okay.
not legal.
right.
So do you want to represent yourself or do you want to have an attorney to represent you?
I need some time to think.
Okay, so I'm gonna set this for another pretrial on March 20th at 8:30 in the morning. And Miss Adams, could I get a notice of hearing for Mr. Musgrove?
Yes, Judge.
All right, so Mr. Musgrove, have a seat on that bench right behind you. And then Miss Adams will give my bailiff a notice of hearing, and my bailiff will provide that notice of hearing to you.